This is Trial Transcripts Exposed by Crime in Court with Heather. Raw courtroom reads with my commentary. Let's dive in. Hi, everyone. Welcome back to Crime in Court with Heather. This is Trial Transcripts Exposed, reading through the Menendez brothers' retrial, which took place in 1996, and it is for the homicides of their parents, Kitty and Jose. And we are on the defense's case. This is part 71. We had Dr. John Wilson on the stand most recently, and then we had a bunch of arguments. Like I said, there's going to be a ton of arguments in this case regarding what evidence can come in for the defense, especially when it comes to the abuse evidence. So, and especially when it comes to Lyle, because he's not testifying. So there's there's still a whole bunch of stuff that needs to be settled regarding that. Um, and Dr. John Wilson was on the stand, but he had other prior engagements that he couldn't get out of. So now we're going to have some other witnesses and arguments and things thrown in here and there. So today we're actually going to hear from, we're going to have some arguments. Then we're going to hear from Brian Andersen, the uncle, brother of Kitty. So we're going to hear from him, and then we're going to hear from Brian Andersen Jr. I believe the testimony of Brian Andersen Sr. is a voir dire, meaning it's not in front of the jury, but we'll get there when we get there. So, just to give you a little overview of what we're doing there. Right now, I would like to thank our founding Justice Insiders, Toyota Girl 67, SLB 29488. May the force be with you, 4313. Jessica Weenan 6079, Mrs. Apples 2007, Butler 89833, Brooke JF, Jen P 773, Boom Chickawawa 1, and Kendall B 5757. You can also be a founding Justice Insider, if you join my channel as a Justice Insider now, from either between now until June 30th, and you can gain that title of a founding Justice Insider. And there are many other exciting interactive perks, I guess, or they're called membership perks if you join. All right, so let's talk about this trial that we are covering here. So, the Menendez brothers trial. We are going to, like I said, again, we're going to start with some arguments. So, give me 1 second. All right. So, it is a new day. This is Tuesday, January 16th, and we just came off of a 3-day weekend. In case you forgot, we just had a bunch of heated arguments, and we're getting back to it with a fresh new week. Okay, the court says, okay, in the trial, the defendants are in court, their lawyers are here, the people are present, the jury is in the room. And I received a brief filed by the defense. The prosecution has not filed anything. Did you intend to file something with the court? No, Your Honor, says Mr. Khan for the state. The court says, before we get into any discussion of the matters filed by the defense, let me inquire. There was reference on Friday to a witness list who was and who was not on the witness list. I haven't seen any witness list in a long time in this matter for whatever reason. Is there one? Ms. Abramson says, yes, there are several. The court says, is there a current witness list which reflects the order in which witnesses are being called? Ms. Towery says, I imagine that the witness list that the prosecution was referring to is a witness list which is entitled Defense Joint Witness List Tentative, in which we sought to break down by week the witnesses who would be called, and that, unfortunately, only went through December 18th. We haven't given them an updated list since then. Ms. Abramson says, but we do have a witness list. There is another witness list that named all the people. Ms. Towery says, yeah, we did give them earlier separately. Actually, I think we gave them a joint witness list earlier that was more extensive than the list broken down by week that goes through December the 18th. I don't have that with me right now, but I'm sure I can find it. I don't even have an extra copy, Your Honor. I don't know how they did all this without like a laptop in front of them. Or, I mean, we did have laptops in like 2000s, I want to say. I mean, there were earlier versions, I'm sure, but it wasn't like as mainstream. So I don't know how they did this without like having, bringing their all their files with them on a laptop. This is all, or like on a flash drive. This is more, you have to bring a hard copy of everything back then. She says, I don't have that with me right now, but I'm sure I can find it. I don't even have an extra copy, Your Honor. I've written on my copy of the tentative list that the petition, I believe, was referring to. Do you have a copy of that? Miss Abramson says, of the tentative list? Mr. Levin says, updated. Ms. Abramson says, my concern, no, my concern is that apparently on the list on the list by dates, which was not complete, Ms. Towery did not include because he's going to be my last witness, Dr. Vickery's name. The court says, I'm not so concerned about the last witness. I'm concerned about all the witnesses between now and the last witness. So let's focus on all the witnesses you intend to call. Who are they and the order in which you intend to call them? Abramson says, I give you a general order, Your Honor. Would you like me to read off the names to the court? Slowly, says the court. Miss Abramson says, okay, today, Brian Alan Andersen, Diane Vandermolen. These are the order for this week as far as I understand it. Kathy Simonton, Joan Vandermolen, Dr. Carrie English, Robert Klaus, and Dr. Wilson. Following Dr. Wilson, Marta Cano, Andy Cano, Peter Cano, Faith Goldsmith, Jessica Goldsmith, Teresa Baralt, Carlos Baralt, Barbara Zussman, Norman Poles, Doug Doss, Roger Smith, Pat Anderson, Noel Nedley. If permitted, following Dr. Wilson, we would also like to call the following witnesses: Sandra Sharp, Barbara Howarth, Charles Wadlington, Meredith Geisler, and Leslie Elmore. Following those witnesses, if they're called, Alicia Herx and William Vickery. And a slight possibility before Mrs. Hertz and Dr. Vickery, we may seek to call Pat Heffernan, Donovan Goodrow, and Robert Rand. Robert Rand is the author who was writing about the brothers. He actually has a very good book about the brothers. Um, and because he was writing about and he took interviews with people, I believe it was was it Donovan Goodrow? It was one of the brothers' friends that he had to go and testify to him saying something that was the opposite of what he testified to. I can't remember the specifics now, but I think it was about like Lyle saying he confessed to me that he did it or whatever, but in like a different statement, he said the opposite. Whatever it was something like similar like that. I can't remember specifics. Anyways, who's talking? I forgot. Uh, Abramson. Ms. Abramson says there's also a possibility, depending on some forensic work, that's still in progress of calling Anthony Pellicano. May I have a moment? Attorneys Abramson and Gessler confirm. Ms. Abramson says, I don't swear, but I think that's it. Oh, I'm sorry. I left off the name of Mary Dominguez, who we certainly are calling, and Emmanuel Zlotolo, who we are calling, but I'm not sure what their availability is. Have they even been scheduled yet, Mrs. Towery? She says, no, they haven't. A number of the witnesses Ms. Abramson referred to have not yet been scheduled, Your Honor. It's somewhat difficult since many of the witnesses live in other parts of the country to work around their schedules. So that the order that she just provided to the court, I don't know if that's a realistic order or not. I know dates that some of the witnesses are unavailable, but that changes. Ms. Abramson says, yes, I have not given that order, Your Honor. With memorizing all of the feedback we have gotten from people about their final or their personal problems with availabilities. That's just my wish list of how I'd like to call them, just for coherence sake. The court says, okay, is that the list? Ms. Abramson says, that's it, as best as I can pull it all together today. I think that's all. The court says, are there any other witnesses to be called by either defendant, or is this a joint list? Mr. Gessler says, that's a joint list, Your Honor. Ms. Abramson says, now this is based on the examination of witnesses thus far, Your Honor. If certain issues based on the court's guidelines become relevant, or we think they've become relevant, there may be more additional people that we'd like to call, and primarily Dr. Cox and Dr. Emery, but we'll see where it goes. The court says, okay, now that is the complete witness list for the defendants. Is that correct? Ms. Abramson says, unless I forgot something, Judge. As potentials, we also have two other relatives, Martha Hollowell and Eileen Cano Hogg, for very brief issues. So we're weighing having to bring people from New Jersey for very brief testimony. The court says, is that now the complete witness list for both defendants? Ms. Abramson says, yeah, I think it's for our case in chief, yes. Is that correct? Says the court. It is, Your Honor, says Mr. Gessler. The court says, all right, now let me hear first any further argument by the defense as to the motion that you filed. Would you supplement anything, or did you want to submit it or on that? Did you want to submit it on that and wait for the people's response? Mr. Gessler says, we'll submit it on that and wait for the response, Your Honor, with the opportunity for rebuttal argument. The court says, okay, did the people wish to be heard? Ms. Abramson says, before Your Honor, I'd like to just join on the record to that portion of the court's talking about the memorandum of points and authorities regarding admissibility of prior threats, etc., regarding Joseph Lyle Menendez. The court says yes. Ms. Abramson says, thank you. We would like in that portion of the argument that talks about a defendant's right to corroborate testimony with third-party witnesses, and also remind the court or refer the court back to a pleading that we filed about 2 years ago, in which we detailed with some specificity the case authority that a defendant should not have to rely solely on his own credibility, that the defense should be permitted to call witnesses who can corroborate the defendant's testimony. The court says, all right, people wish to respond to that pleading? Of course. Yes, Your Honor, says Mr. Khan. He goes on to say, it's our position that the incidents that counsel seeks to introduce are not admissible. Counsel wants to introduce such prior conduct based nothing more upon an assumption that the defendant either recalled these incidents, or that the defendant considered these incidents, or that the defendant somehow relied upon these incidents. And this is nothing more than an assumption argued by counsel. There's absolutely no evidence before the court of the significance of these incidents. If we are to make such assumptions, on what basis can we do so based upon what we think the defendant might be able to recall, or based upon what we believe the defendant might have considered or relied upon? And by what standard do we determine, on what standard do we base that assumption? Even if we were to base it on such an assumption, do we consider the remoteness of the incident, or should we consider the remoteness of the incident? How many years ago did the incident take place, and how trivial was the incident? And was this something that was reported to the police? Was it something that the defendant spoke about? Is it something that appeared to be significant in the defendant's life? Certainly the court should consider these matters, and there's no basis upon which the court can consider these matters because there's no evidence before this court. So I would submit that the court is simply backlashing any foundation upon which it can find that any of these incidents played any role in the behavior of the defendant, absent some testimony from the defendant upon which he can rely. Court says, okay, let me inquire, who is the witness who is first to be called today? Brian Alan Andersen, Your Honor, says Ms. Abramson. The court says, and the people did file a specific motion directed at his testimony. Yes, Your Honor, says Mr. Khan. Abramson says, basically. Court says it was filed last Friday. Abramson says, yes, I have not read it carefully because just glancing over it, they object to every single thing he has ever said and only offer 50 boilerplate objections. There's no actual reason for argument. We're going to have to go through every single thing he said for the court to rule on that he may or may not say. The court says, okay, with that assumption, perhaps you can give me your response argument to what the people were saying or not, Mr. Gessler. Mr. Gessler says, yes, Your Honor. As to Alan Andersen, I think I set forth on Friday the nature of the material that we seek to offer on behalf of Lyle Menendez. Basically, it is he was a witness to what we called the Jeopardy game at the dinner table. This was back in 1977 and shows an ongoing course of conduct as to how dinners were conducted in the Menendez household as corroborative of Perry Berman of Perry Berman's testimony as to that. I believe also it is independently admissible as to the establishment of fear in in Joseph Lyle Menendez by his father because of the manner in which these games were conducted, in which he had to get up from the table at age 9, look at an encyclopedia or newspaper for the answer of the question, that he was belittled if he did not have the answer, that these subjects encompass such things as business, tennis, the front page of the newspaper for a 9-year-old boy, and that if he failed the test, his father would require him to sit a few inches from him, forehead to forehead, all matters which were observed by Alan Andersen at that time and described as a very tense time type situation. A second incident we seek to offer from Brian Alan Andersen is that Lyle Menendez, as well as Eric, was circumstantial evidence. So they're not calling. I misspoke. They're not calling, and I'm wrong on who they're calling. They're only calling, I believe, the junior, Brian Andersen Jr. And one is not in front of the jury, and then he does get to testify. That's what I'm thinking, because that's the only thing that makes sense. Because Brian Anderson Sr. isn't even he wouldn't be called by the defense because he he wouldn't be a good witness for the defense. He thinks that the brothers deserve to be where they are, or he did. He's no longer with us, but he recently passed last year, I think. So a second incident we seek to offer from Brian Anderson is that Lyle, as well as Eric, was circumstantial evidence beaten with a belt that Jose Menendez, when he came home, would often take the belt off and snap it in the presence of the boys, which would mean that someone was to be disciplined. That when these occasions occurred, Mrs. Menendez would turn up the TV, tell Alan Anderson not to go down the hall. He would hear, however, from his room the swish of the belt, and the next day he was able to observe bruises on Lyle Menendez in the lower buttocks and upper thigh area, consistent with having been struck by a belt, to the extent that sometimes he had difficulty walking other than with a stiff gait. A third incident that we are offering is one in which Brian Anderson this is Junior, was outside with both Lyle and Eric. Brian Alan Anderson was upset with Mrs. Menendez and Mr. Menendez, and so he took some shears or cutting device and cut off Mrs. Menendez's flower heads from the stem. When Mrs. Menendez came out, she did a slow boil, going into a larger one, and at that point, Alan Anderson did take the blame for what he had done and told Mrs. Menendez that he had, in fact, been the one to cut off the flowers. However, he was not beaten for this, but Lyle Menendez was. Again, hit with the belt from the swishes and limped the next day from the activity for which he was beaten. Probably like, how could you let him do that? Like, I don't know, blame him in that regard, I guess. I don't know. I don't know how you would blame Lyle and beat Lyle for it. Not that I'm saying either one of them should have been beaten. I'm just saying, like, how do you take your anger from one kid and put it onto another? Your own. There's one more incident that Alan Anderson can testify to concerning fear of Lyle Menendez, of his father, that that is that when Lyle Menendez was 9, he, on 4 separate occasions, asked Alan Andersen why Lyle Menendez received a punishment for things that, on occasion, all 3 boys had done. He asked Alan to intervene on his behalf to Jose Menendez. He appeared to be trying not to cry when he would relate these requests to Alan Andersen, but Alan Andersen basically said, "No way, I'm not taking on your father." He can further relate that crying or tears was something that Jose Menendez would not stand in his sons and would send them out of his presence if anything like that, like emotions, appeared to be coming about, because tears were not a manly reaction. These are the things that we seek to introduce through Alan Andersen. I believe they are all corroborative of a lifelong fear by Lyle Menendez of his father beginning at an early age, and all play a part in the events of August 20th, 1989. In response to the district attorney's argument, there is no place in the law, case law, nor statutory law that requires a defendant, if he does testify, to say that I had in my mind or I was considering past encounters between myself and the deceased or the victim of the attack in order to justify imperfect self defense or perfect self defense or heat of passion. The law appears to recognize that we are all products of our total background and environment, particularly in a person to person type relationship, and most especially that of a parent and child. I've known no case in which a defendant who testified to prior acts of the deceased against him, nor the prior knowledge of aggressive tendencies of the deceased towards him, was required to state on the stand was that in your mind at the time that you reached for the gun, reached for the knife, or whatever encounter occurred. So they don't have to testify and say, I was thinking about the time that my dad did this to me when I was 7 years old. You don't have to do that. You just have to prove that there's reasonable belief to be afraid of this person. I think this is because in both law and in reason, it is understood that this is not conscious thoughts that a defendant is developing at the moment of truth with the encounter with the deceased. These are all a part of the fear that the deceased had that the deceased had engendered in the defendant, but are not consciously uppermost, in which you are segregating all or any of past life experiences with this particular individual to then govern your behavior at that particular moment. So there is no requirement in law, such as the district attorney has mentioned, of a defendant saying, I considered it. If there is no such requirement for direct evidence, there is no such requirement under circumstantial evidence, in which the circumstantial evidence can be heard and evaluated by the jury. There's also no requirement that a complaint be made to the police of prior aggressive conduct by the deceased against the defendant, and that's most particularly true in a household situation of a parent and a child. In fact, it would be very unusual that such a complaint would be made to the police by the child. In addition, the requirement as to whether it was spoken about, one of the things that the district attorney mentioned as a precondition to the evidence, that is exactly what we are seeking to put in here, that these things were spoken about by Lyle Menendez to Alan Andersen at an early time, well before the particular homicide, and therefore having indicia of truth, because it's certainly not self-serving complaints that he made in those years. He spoke to Alan Andersen about his fear of his father and why he was being punished for things he had not done. He spoke to Diane Vandermolen concerning the sexual molestation that was occurring at that time, and we have her direct evidence as to Mary Menendez's not response. This didn't happen, or forget about it, or things of that nature. She just ignored it. Unfortunately, an incident which was repeated some 14 years later when Eric Menendez was the subject of the ongoing molestation by his father and the encounter at the stairs by Lyle Menendez with both his father and his mother refusing again to intercede in this particular matter. I think all of these matters are corroborative for Lyle Menendez. I would ask that they be admitted on his behalf. The court says, what is it that Eric Menendez wished to obtain from this witness? From Alan Andersen? Asked Miss Abramson. Yes, says the court. Ms. Abramson says, well, I can do it that way, or I can tell you what I'm going to seek to obtain that he testified to last time. The court says, no, just what is it that you're offering? Ms. Abramson says, you want the direct? All right, let me go through in a summary fashion. The court says, who would be questioning the witness first? I am, says Ms. Abramson, because I have far more topics to cover. First of all, there's a couple of main themes here with his testimony. The first, and I think simplest to deal with, is clear cut acts of violence by the parents to my client, and violence and threats of violence, and evidence of complicity by Mrs. Menendez in the degradations of Mr. Menendez, and other facts that corroborate the testimony of my client in significant areas. So let me just go through it. One of the things that I'm seeking to bring out through these witnesses are what Dr. Wilson calls symptoms of post traumatic stress disorder behaviors in my client, changes in my client, which he indicated were relevant between the witness, Alan Andersen's first visit in 1975 before the onset of the molestation and his second visit in 77 after it had begun. So the first real topic is that he did note, as he testified last time, the very dramatic change in Eric Menendez's behavior between 75 and 77. And his description of that change from a happy, outgoing child to a sad, withdrawn, introverted, fearful child. The court says, let's have the witness step out since we're going into all the specifics. The court says, let's have the witness step out since we're going into all the specifics. Ms. Abramson says, this is all stuff that was previously testified to, Your Honor. The court says, still, I'm asking him to leave. All right, says Ms. Abramson. Brian Alan Andersen exited the courtroom. Ms. Abramson says the second area is violence between the parents witnessed by the witness and by my client and his observation, the witness's observation of bruises on Mrs. Menendez. This not only is a factor in the development of post-traumatic stress disorder of my client, which Dr. Wilson will testify to, but also it corroborates Eric Menendez's testimony concerning this and also corroborates the statement he made on the 12/11 tape, the December 11th tape that with Dr. Ozio, about seeing blood on the bed after fights with the parents. And these are loud screaming fights and the sounds of blows and the observations of bruises on Mrs. Menendez. Okay. So he thinks that Jose was beating Kitty and they would have fights and there'd be blood left on the bed and bruises on Kitty Menendez. So we also seek to elicit brief description of the tense and confrontational dinner times that the family had. It corroborates Eric Menendez concerning later tension and these kinds of things later on in his life. And Mr. Gessler had indicated it contradicts the implication in questioning of Perry Berman that what Perry Berman saw was somehow idiosyncratic and not typical of the confrontational and tense atmosphere in the home at dinner time. It also explains, this may be a bit on the subtle side, but it also explains why, when Eric Menendez is asked a question, he feels it necessary to give every possible answer, something that the court chided him for when he was testifying, and the witness will indicate that to you, he will indicate that you had to give Jose Menendez an answer, and ultimately you had to give him an answer that he would accept. The court says, would you characterize that as just a bit of a stretch, that argument? Ms. Abramson says, I said it was subtle, Your Honor. I don't think a stretch. It is subtle. I shall move on, however, seeing the court's disinterest in subtlety this morning. All right, there are certain things that he testified to last time that I'm not getting into, so I'll go to the next. I would have him testify to the fact that discipline by Jose Menendez was always imposed one-on-one. He would go off alone with my client or with Lyle Menendez. He would discipline them in private, behind closed doors. The witness could hear the sounds of discipline. The witness was instructed by Mrs. Menendez specifically that he was never to approach the room where Jose Menendez was alone with either of the sons during these private sessions for any reason. The witness also would testify that there were times that Jose Menendez would invite or lure, as the case may be, Eric Menendez uh, into a room and be alone with him in a non-disciplined setting, typically in the evenings after they had showered together. I would also elicit the harshness of even the nonviolent discipline with respect to Eric Menendez, who at an extremely early age would be locked in his room sometimes all day as discipline. I would also elicit the nature of the offenses for which Eric Menendez received whippings with a belt and of as many as 6 strokes. There are 3 specific incidents that the witness recalled that results in Eric Menendez being strapped between the ages of 4.5 when he first stayed with the family in 1975 and 6.5 when he stayed with the family in 77. And the 3 things were Eric accidentally tipped over a shelf in the garage, leading to paint cans being spilled, and he was whipped with a belt by his father for that. At 4.5, Eric Menendez wandered off the front yard and crossed the street in Monzi. But whose fault is that? The parents for not watching him. He was not permitted to leave the front yard, and he was immediately brought back home by Mrs. Menendez. That night, he was strapped by his father for that. And a third occasion that the witness recalls is Eric Menendez attempted to climb the backyard fence so that he could go over to the other side. He was caught and not successful in leaving, and he was strapped with a belt for that. The witness would testify that the very worst thing worst in the sense of a transgression or wrongdoing that he ever saw Eric Menendez do, was the incident with the paint cans, which was an accident. I would seek to elicit the manner in which the belt was displayed to Eric Menendez, even when it wasn't used as a threat of violence, and how Eric Menendez reacted to that. I would seek to elicit evidence of what I call hypervigilant or what could be characterized as hypervigilant behavior on the part of Eric Menendez during that 1977 visit, where he would all 3 children at that time in the household, Mr. Anderson, Lyle Menendez, and Eric Menendez, would watch for Mr. Menendez's arrival home from work at night, stand at attention when he entered the home, stand at attention like you had to like he was like you're in the military and he's your captain or whatever, your sergeant. And the witness recalls Eric Menendez staring intently at his father to determine his mood to see if anyone was going to get punished or hit when his father came home. I would seek to elicit that whenever Jose Menendez took the belt and went into the bedroom to strap Eric or Lyle, Mrs. Menendez would turn up the television set to try to prevent the witness from hearing exactly what was going on, that she too never went to their room when they were alone with their father, whether for discipline or in a non disciplined setting, when the father was alone with either of the children in their room. I would seek to elicit these frightening rages that Mrs. Menendez directed towards Eric Menendez and the things that she would scream at him during the course of these rages. I would seek to elicit that there was a rule in that house that crying was a weakness, and that when Eric Menendez did express emotion by crying, he was punished for doing so by being isolated from the family. I would seek to elicit that Eric Menendez was not permitted to have any friends, was kept isolated, and was totally involved by his parents in sports activities all the time. I would seek to elicit just very briefly that Mrs. Menendez would drive exceedingly fast and get involved in dangerous maneuvers with Eric Menendez in the car as a very young child without a seatbelt. I would seek to elicit that to corroborate Eric Menendez's testimony concerning the nature of the torturous sexual behavior and the fact that he was given the excuse by his father that its purpose was to develop a high tolerance for pain, that this witness specifically recalls sharing Jose Menendez make comments about the need to have a high tolerance for pain, that it was a matter of mind over matter, that when his children would complain about being in pain, he told them they had to continue to work through it. Whether this was in boxing or wrestling matches, he encouraged them to engage in with each other, or the witness, or whether it had to do with injuries they were having in sports where he forced them to continue to play, quote, through the pain. And, Your Honor, I would submit that I would like to have a 402 hearing so the court can hear with more detail than was presented the last time, the bicycle incident that the court previously indicated the court believed was, quote, typical of how people train their children to ride bicycles. I think if the court hears all the facts, the court will agree that there was nothing typical about this incident, and specifically, what the witness recalls is that Jose Menendez would run for 10 to 20 feet behind Eric Menendez on a two-wheeler before Eric Menendez had learned to ride that bike, push Eric Menendez down a steep incline into a cul-de-sac, and Eric would repeatedly fall off the bicycle. On one such occasion, after repeatedly falling, Eric Menendez fell off and seriously injured his left elbow and was bleeding profusely, and Mr. Menendez put him back on the bicycle. Eric Menendez could not steer the bicycle at that time because of the injury to his arm, and he was pushed down the hill nevertheless, and he fell again. Now, I would simply point out to the court that in this day and age, we recognize that children riding bicycles on their own should be wearing helmets because of the potential for fall injuries from children falling off bicycles. We are not talking about a parent who runs behind a child trying to learn how to ride a two wheeler. We are talking about a parent who, in Dr. Wilson's opinion, which we'll be seeking to offer, this behavior is life threatening, endangering, and Eric Menendez's behavior. Mr. Andersen remembers Eric saying, "Daddy, I don't want to do it anymore. Please, Daddy, do no," and crying and screaming in terror as he's being pushed down. Now, there are many different ways to treat children, and this is not a case about things so bizarre that there aren't more moderate and normal versions of them. But our point is that this isn't the moderate and normal version of this. This is a willful act of causing intentional harm to my client, which, frankly, Your Honor, resulted in a much more serious permanent injury than the strappings with the belt, which seem more obviously punishment. This was punishment for Eric Menendez being a sissy because he was afraid and because he did not learn how to ride his two wheeler at 4 the way that Lyle Menendez did. This was a form of torture and punishment to him. So, we would be seeking to introduce that with the detail that I have explained to the court so that its true nature not be misunderstood, just a helpful parent seeking to help the child learn how to ride a bicycle. Let's see what other things I would seek to elicit. In a one sentence question and answer, that Eric Menendez was involved in swimming to a large extent when the family still lived in Muncie, and that Jose Menendez would take Eric alone to the pool and train him without anyone present to corroborate my client about his father holding him underwater and pushing him underwater and the fearfulness he had that his father would accidentally drown him. The fact that the witness saw Jose Menendez and his sons take showers together routinely. The fact that at a young age, this witness saw the family when they lived in Hinsdale, and Eric Menendez was between the ages of 2 months and 2 years. That at that age, the witness saw Eric Menendez frequently go to his mother and seek her affection, and that at that age, she would often give it and pick him up and hold him and pet him. That by the time Eric Menendez was 4.5, and at the time Eric was 6.5, the only times the witness saw him go to his mother was when he would cling to her, seeking to escape punishment from his father. And his mother would tell him that she couldn't help him, that she would say, "Go with your father and take your punishment." That there was no sign from the time 1975 when he stayed with the family in 77. There were no outward signs of affection displayed by Mrs. Menendez towards Eric Menendez other than smiling. If I can have a moment. that Eric Menendez during 1977 would display unprovoked and uncontrollable outbursts of irritability and tantrum behavior where he would grab newspapers and other papers and rip them up, and never aimed harm to another person but just unpredictable expressions of irritability, which the court may recall Dr. Wilson indicated was one of the symptoms of post-traumatic stress disorder in children, and that when Eric Menendez would have these displays of irritability and tantrums, Jose Menendez would frequently slap him on the hand or slap him on the butt and force him into the room by grabbing him and pulling him into Eric Menendez's room. The witness will testify that in the rages that Mrs. Menendez directed against Eric and Lyle Menendez, she frequently screamed that she wished they had never been born and that they ruined her life. This is true in the 77 visit. He does not have those specific recollections about the 75 visit. Let me just review my summary of this previous testimony to see there are many other things he testified to before that I'm seeking to elicit. No, I'm not seeking to elicit, sorry. There's a pause, then Ms. Abramson continues and says, yes, one of the components of Mrs. Menendez's rage behavior was her smashing and breaking things continually, which was very frightening. He would also testify that the witness that he observed even in 75 and 77 that Mrs. Menendez taking prescription drugs and it affecting her state of sobriety. The witness describes her as being spaced out, which corroborates Eric Menendez's earliest memories of his mother using drugs, prescription drugs, obviously. Also, that Mrs. Menendez in 1977 frequently called Eric Menendez names like stupid and dummy and idiot. That's it, Your Honor. Mr. Gessler says, we join, Your Honor, in the offer of proof made by Ms. Abramson on the independent grounds for Lyle Menendez that this is offered to corroborate the basically star witness for the defense in this case, that even if this were a separate trial, we would be offering the same testimony that Mrs. Abramson just delineated for the court. The court says the star witness being who? Mr. Gessler says Eric Menendez, Your Honor. The court says, okay, all right. What is the people's response? Mr. Khan says, it's contained primarily in the two motions we filed with this court. First motion is the motion to exclude the testimony of the number of witnesses which we addressed under the categories of teachers, friend, family, and coaches, and court ruled in regard to that motion that much of the testimony from the first trial would not be admissible as it relates to teachers and coaches and friends, and essentially with the information that counsel is now seeking to present to the jury the same type of information that the court had ruled inadmissible when it comes from teachers and coaches and friends. Now, the only difference is it's coming from family members. I recognize that at the time of the ruling, the court realized that the family members had some background information, particularly relating to the events of immediately following the murder in which the defendants might have some relevant information, since we were challenging their actions and their behaviors immediately following the murder, and it was difficult because of the breadth of the information that the witness provided in the first trial to entirely exclude their testimony, as the court did in regard to a number of teachers and coaches and friends. However, that type of information aside, here we are now looking at the same type of trivial incidents that the defendant sought to introduce through the testimony of teachers and coaches and friends, and I would submit to the court that this is, as we argued at length in a lengthy motion that we filed with this court to exclude such testimony, another way of simply putting the victims on trial in this case. The evidence is not relevant and it should be excluded under Evidence Code Section 352, and I won't burden the court with going through all the arguments that I made in that lengthy motion. The court is familiar with all those arguments. We feel that now the time has come to simply rule that the testimony is inadmissible. I would contest all of the information which Ms. Abramson seeks to present, every single piece of it, as simply irrelevant and subject to exclusion under 352. You just want to exclude everything Ms. Abramson seeks to present. Every single piece of it. As irrelevant? Come on, get out of here. It can't all be irrelevant. Not only because the defendant has already testified to background information which is sufficient to put before the jury the issues that he is claiming, but he also called an expert witness who testified in regard to these matters, and the expert witness has already stated his claims. The defendant should not be able to present it through the defendant. Huh? The defendant should not be able to present it through the expert witness and then once again present it through once through the defendant, then again through the expert witness, and then again through a third time, just literally bombarding this information with the same type of claims over and over again. The expert has testified to his opinions and the basis for his opinion, and that is sufficient. And I asked the court not to allow any of the evidence referred to by Mrs. Abramson. So nothing, just anything she just said, we don't want it in. He also asked the court to exclude all of the evidence referred to by Mr. Gessler because that evidence, which he seeks to categorize under the heading of fear, simply seeks to make it more relevant by putting it under the title is really not relevant either. We cannot assume that the dinner conversations that took place in the Menendez household had any bearing upon the actions of the defendants on the date of August the 20th of 1989. There's no basis to make that assumption. If the expert can indeed draw a connection between the two, then the expert can and will draw such a connection, and we should not hear testimony concerning cutting the heads of flowers off, or Lyle Menendez asking this witness to intervene and try to keep his father from being not so harsh on him, and certainly not any evidence relating to the beating by means of a belt when the witness observed no assault upon the defendants. He was not an eyewitness to any assault, and once again, Lyle Menendez did not testify and would not establish any basis for the introduction of his testimony. So once again, as I argued in our motion to exclude the witness in the entirety of his testimony, and as I reiterated in the motion recently filed as I went through point by point each specific area of testimony that the witness would testify to and offered grounds for the objection of that testimony, we reiterate all of those grounds at this time and ask that this witness testimony be excluded in its entirety. They don't want Brian Andersen Jr.'s testimony to come in because it backs up Eric's. It proves that the abuse really did happen. Anything that does that, the state wants out. It's very apparent. The court says, is it the people's position that you will challenge Dr. Wilson's testimony by attacking the basis of his opinions that these events that he describes or refers to or summarizes did not occur? No, Your Honor, says Mr. Kahn. The court says, as other witnesses have described in previous testimony or in interviews? No, Your Honor, says Mr. Kahn. We are not going to be challenging the bulk of these trivial incidents that the witnesses relied upon. We are going to challenge the allegations of sexual assault, pointing out to the jury that there's no evidence of such allegations. You've got to be kidding me. We are not going to be challenging what took place at the dinner table and whether or not there was. The court says, let's get beyond the dinner table to other incidents that have been put forward by the defense in their offer of proof here. Are you going to be challenging Dr. Wilson's description of these events or his referral to them and the basis for his opinion? No, Your Honor. Ms. Amerson says, Your Honor, I would point out what's a little confusing here, is the court wouldn't let Dr. Wilson describe the events. I specifically, if you can recall the way we limited his testimony, he's only been able to say that there's evidence in a generic sense that these kinds of things happened. He was not able to give specific details, a recitation of what the witnesses had said about these events in detail, so we wind up with no one being able to give the details. And moreover, I'm unaware of any case authority that says that we are not permitted to corroborate our client's own recollection of fear-inducing events, whether Dr. Wilson describes them or not. not everything in this case. I mean, it is unfair for the defense to have to go to the jury with only the credibility of our client and of a mental health expert witness, of whom juries are ordinarily quite skeptical, in order to support the allegations of prior abuse, particularly fear inducing acts that are rationally connected to the sense of fear and terror from assault by the victim. So to say they're not going to challenge the events, they have challenged them. They objected specifically to Dr. Wilson relating specific facts of this nature, these underlying observations of witnesses, or connecting them to the source in a way that supports the source's reliability, such as a person who lived in the home for 2 months who is related to the victims. So, whatever they say now about, oh, yeah, they're not going to attack his credibility, they have already objected to his testifying about any specificity. And I do not think that it is appropriate to say that if a mental health expert can refer, and certainly it's not fair to Dr. Wilson. It's beyond the ability of one witness to have to recite every single incident in detail so that the jury gets the real feel for what happened, to make him be the entire background of this case. I mean, he's good, but he's not that good. No one is, nor should it all depend solely on his credibility. The jury, I believe, should have the opportunity to hear people who lived in this home, and there were only three such people ever who were closest to this family, who observed things that only they, among all the hundreds of people that may have interacted with this family, were in a position to see. So that in order to corroborate what my client says was the significant treatment that even he was limited in testifying to, that he suffered at the hands of his parents. And to say we should be able to do it all with the expert and with the client in writing a new rule with which I am unaware, that prevents us from putting on the most persuasive type of corroborating eyewitness evidence. Court says, all right, anything else? Okay, we'll take a short recess and I'll give you those materials and we'll resume. Ms. Abramson says, by short, Your Honor, do we have a chance to leave the courtroom, get coffee and things like that? We'll resume at 10:30. And what we'll do is have, I'll talk to the bailiff. We'll resume at 10:30. Ms. Abramson says, thank you, Your Honor. They got a 30-minute break. The court says, we are back in session without the jury. We have the trial participants present and will proceed with the conclusion of the hearing regarding the proposed testimony of Mr. Andersen. In addition to reviewing the materials directly related to the testimony of this witness, I've also reviewed the rulings made and the argument made in regard to the proposed testimony of other witnesses, which was the subject of a hearing resulting in rulings by the court on October 5th of last year. I noticed that potentially some of those witnesses who were ruled by the court to be inadmissible are still potential witnesses identified by the defense on their current witness list. At the time the court ruled in regard to those other witnesses, so-called source witnesses of October the 5th, the court based its ruling on Evidence Code Section 352 primarily, and also Section 350 relating to evidence. And the court at that time analyzed the proposed testimony of each witness, or each witness who was identified by the defendants as potential witnesses. I reviewed their former testimony and the offer of proof, and in doing so, the court excluded the testimony of many of the witnesses who were proposed by the defense, and that hearing, as counsel correctly stated, involved primary non-relatives. The witnesses who were the subject of the court's rulings at that time were the former teachers and coaches and friends who were proposed as witnesses by the defense, and many of whom testified in the first trial. So all those coaches and teachers, he has already ruled that they're not coming in this trial. The court excluded the testimony of many of the witnesses, approximately 9 of the witnesses who were proposed by the defense, some of whom the court ruled admissible. The court indicated would be admissible for a limited purpose, not for the broad range of testimony some of those witnesses offered in the first trial. A court held in abeyance a ruling upon the proposed testimony of other family members for the reasons stated by the prosecution here today, reiterating what I had said on October the 5th, that there were certain matters that those witnesses, family members, would otherwise be permitted to testify about anyway. They would be coming in to testify about those events, and therefore there was no reason before they actually came in to deal with the specifics of their testimony. And now we are in a position to more clearly focus on the specifics of their testimony. The people object to the entirety of the testimony of Mr. Andersen, and likewise have filed written objections to the entirety of the testimony of other proposed witnesses, including Joan Vandermolen, Diane Vandermolen, Marta Cano, and Robert Klaus. I believe those are the documents that have been filed so far by the prosecution. And in addition to objecting to the entirety of the testimony of those witnesses, the prosecution objects to specific instances about which of those witnesses testified in the first trial. The people anticipated, to some extent, those things that the defense would be offering in the testimony, for instance, of Mr. Anderson, some of which the defense indicates that they would indeed be offering. And without going through each item identified by the prosecution in their written objections to Mr. Anderson's testimony, it's my impression that there were some things that the prosecution objected to that the defense is not offering in Mr. Anderson's testimony, that there were some things that they have elected not to put forth, but many of them were identical to the offer of proof by the defense in our hearing this morning. Many of the things the people had objected to in the written document filed on January 12th. The court is faced with the people's objections under Section 350 and 352, and again, one has to make reference to the purpose for which the evidence is being offered and the issue in litigation in dispute that the jury is called upon to resolve. And the principal issue in this case is that of the mental state of the defendants at the time they killed their parents. This is something that has been referred to on prior occasions by the court and also by counsel. This is not a trial in which the life history of the defendants is in dispute. It's not a trial in which specific instances in their childhood are in dispute. The only relevance of any of their material referred to in the offer by the defense is what, if any, impact these prior incidents had on the mental state of the defendants at the time they killed their parents. And each defendant had his own mental state. Each is being tried by the jury separately. The jury has to resolve the issue of mental state as to each defendant separately, although there has been some reliance by Lyle Menendez upon the testimony of Eric Menendez to establish his mental state circumstantially or by declaration of Lyle Menendez and descriptive testimony, things of that nature, which were referred to by the defense in their arguments on the 12th of December. The 12th of January, rather, in the transcript of volume of 261 on blah blah pages, and also some other material in volume 71, which was received without objection. But the jury is called upon to resolve issues of mental state as to each defendant separately because they will be deciding the case of each defendant separately, although there certainly is commonality in the prosecution's evidence and commonality in the defense evidence as to both defendants. Those are general statements of the issues before the court that the court is evaluating. The offer of evidence here, the material described by both Mr. Gessler and Ms. Abramson, in the context of its relevance to the mental state of the defendant at the time they killed their parents. Eric Menendez has testified to his mental state. He has described it. There is now before the jury additional evidence by Dr. Wilson to corroborate the mental state of the defendant, Eric Menendez. Initially, when these matters were brought up, as far as the admissibility of testimony or evidence from so-called source witnesses, the court indicated that such witnesses would have no relevance until the defendant testified and until the expert called by the defendant testified, and then the relevance would be as a basis for the testimony for the expert, and the rulings upon admissibility would be connected to what was that the expert testified about. We had the beginning of Dr. Wilson's testimony last week and then it stopped. Apparently, there is a scheduling problem which prevents Dr. Wilson from being here until the end of the week. I don't recall now. I thought it was Thursday, but I heard perhaps it was Friday. I don't recall which day it is that he's supposed to be here. Ms. Abramson says, it's Friday. The court says, so we have yet to hear the totality of Dr. Wilson's testimony and the materials upon which he derives his opinions as to whatever opinions he will be permitted to present to the jury regarding the mental state of the defendant, Eric Menendez, at the time that he killed his parents. This judge likes to play these little, like, loop-de-loop games where the defense is just stuck in a loop and can't ever win. Like, well, I have to hear the completion of your expert's testimony before I can rule on anything else. But your testimony or your expert's not going to be here to testify until Friday, so I can't. My hands are tied. I can't do anything. This judge likes to give the defense these kind of cyclical type of arguments where there's no winning for the defense ever, and it's really kind of frustrating to watch this over and over again happen. He continues on to say, to some extent, the factual predicate for the court to rule on the so-called source witnesses isn't complete because Dr. Wilson hasn't completed his testimony. We have no testimony from Lyle Menendez, other than the reference by Eric Menendez to statements made by Lyle and certain descriptions of Lyle's demeanor at the time relevant to the time of the killing of his parents. To restate what I said at earlier hearings, this is not a trial in which the jury is called upon to determine whether or not the defendant, Eric or Lyle, was or is an abused person. That is not the purpose of this trial. The purpose of the trial is to determine the mental state of the defendants at the time that they killed their parents. The only relevance of whether they were the victims of violence or any other action by the parents on earlier occasions is whatever value those other circumstance has in evaluating their mental state at the time of the killings. So again, another like cyclical argument where you can't win. And the court is called upon to review this material in light of the fact that this evidence, the defense calls it circumstantial evidence, it really falls well below the circumstantial evidence that one normally looks to describe one's mental state at a particular point in time with references made to the instances that occurred 10, 15 years before the crime. It is not the type of evidence that one normally would look at to ascertain what somebody was thinking about at a particular time. That is not to say that such evidence is necessarily not admissible, but it certainly gives one pause to examine it more carefully in view of its remoteness in time and its potential for confusion of issues. This just proves to me the judge knows nothing about abuse because that thing that Jose did to violently punish Eric at the age of 6 can leave lasting impressions that make him fear his father for the rest of his life. So all of the things that Jose has done, like building up, could have been enough to, just some of them individually could have been enough to put Eric in like a PTSD state and to be struggling, in with um I don't know what I was going to say now. To put him in like that PTS state, to traumatize him. So just like one or two of his acts could have done that. But if you combine all of them, can you even imagine how fearful this person would be of his father if we, combine or at least, let the jury know that this is a pattern of abuse. There is always, this happening multiple times over and over again. Sorry, my neighbor was here and he had the wrong Amazon package, so I had to pause and deal with that. Hold on, just for 1 second. So I'm back. All right. So I don't remember where I left off. I was probably in the middle of a sentence. So this is the judge speaking, I believe. Let's find out. whoever it is has been talking for quite a while. Oh, nope. Yep, it's the judge. Okay, so the judge is speaking. And he said, it is not the type of evidence that one normally would look at. And to ascertain what somebody was thinking about at a particular time, this is not to say that such evidence is necessarily not admissible, but it certainly gives one pause to examine it more carefully in view of its remoteness in time and its potential for confusion of issues. And the confusion of issues is this, that, as I said, this is not a trial to determine whether the defendants were abused or fit a particular psychological diagnosis. Those issues and the abstract are irrelevant and would normally play no role in a jury's decision as to whether a person did or did not kill someone and what that mental state was, if they did, at the time of the killing. The material only has a basis for admissibility as a foundation for whatever psychological evidence is received in the course of the defense to substantiate or corroborate the mental state of the defendants as otherwise established by the evidence. This is not a situation where we're dealing with the circumstances immediately surrounding the death of the parents, but incidents that occurred over a long period of time and in remote time frame. Further, and to follow up on my comments regarding the potential for confusion of issues, that is a real concern for the jury would be focused on, and the attention of the jury would be on the early childhood years of the defendants, and these specific acts and instances are described, and somehow the focus of the trial would then shift from what happened on August the 21st, 1989, to what happened on May 1st, 1975, as to what someone was doing at a certain time and how someone looked at a certain time. And the potential there is clearly for confusion of issues. That at that point, the issue no longer is what happened at the time of the killing and why it happened, but what happened in 75 or 77 and some other year long since past. Further, the court is aware that the defense intends to propose to call several witnesses to testify to similar instances. They might describe different specific acts, but the purpose is the same, to testify to an accumulation of acts over the childhood years of the defendants, and in court, in addition to being concerned about the potential for confusion of issues, is also concerned about the cumulative nature of such evidence, which tends to compound the potential for confusion, also consume a great deal of time, and also the court is concerned about the potential for undue prejudice in this case. The people reiterate and restate their position that the victims are being put on trial. I take that as a shorthand way of the people arguing that there's potential for prejudice in that the victims and the conduct of the victims that have no relevance to the killings, but I would argue, hold on, and the conduct of the victim that have no relevance to the killings are then put before the jury. Bad acts alleged to have been committed by the victims, which have very little probative value but have great potential for prejudice in that it puts the victims in a bad light, their character and personality in a bad light, without any real probative value. Those are my preliminary remarks. There has been specific instances described here, and I would like to get to them because it goes beyond just generalities here. Let me repeat that. As I look at it, there are more than one witness. There is more than one witness who the defense intends to offer about the same time period. The witnesses who would perhaps be describing and would be describing different instances, but basically the purpose for which the evidence is offered would be the same. So the court would, in addition to whatever rulings the court makes in regard to Mr. Andersen, keep in mind that what it is that he is permitted to testify about, or those things that the court rules are remote in time or irrelevant, would not necessarily be permitted in the testimony of another witness, whoever that witness may be, an aunt or cousin. So let me review here the specifics of what it is that is being offered. As to Lyle Menendez, again, he has not testified. The only evidence before the jury as to his mental state, that of the testimony of Eric Menendez, received without objection of statements made by Lyle Menendez and demeanor of Lyle Menendez at or near the time the parents were killed. The court is aware of the cases cited by the defense. I've read them. I've read all the cases cited by the defense, including the DeLeon case, which also seems to crop up. I don't know why it is that in the defense briefs it allows. Why in the defense brief it always seems to materialize. Can't figure out why. However, as far as the specific testimony offered by Mr. Gessler on behalf of his client, keeping in mind that there is still the cumulative nature of the testimony to deal with if it's being repeated by other witnesses, the only material that I see that would have any relevance would be, and it is remote, and let me say this as well. Counsel for Eric Menendez complains that the court restricted his testimony in great detail. That is not true, and there was a great amount of evidence received over the prosecution's objection from Eric Menendez about his early life history, and a lot of description of detail of that, and the reasons for the offer was that it was the basis for the opinions of Dr. Wilson, and the evidence is in. And that doesn't necessarily mean that we then jump from there to allowing other witnesses to testify to all of the events described by Eric Menendez. The court says, getting back to Lyle Menendez, I thought he was still talking. I don't know. So getting back to Lyle Menendez, the only material that I could see that is relevant as proposed from the testimony of Mr. Andersen is a little remote. But based upon what has been received so far, I see there is some relevance to the beating by the belt and would permit testimony. I understand it's not direct evidence of the exact observations of Mr. Andersen of the belt hitting flesh, but the intention, if it can be established that the incident occurred circumstantially, would have potential relevance as to the state of fear in taking into consideration all the other evidence that has been received. But that is the only material I could see that would have any relevance from Mr. Andersen to Lyle Andersen as offered by Mr. Gessler. As to Eric Menendez, there is a whole list of things described here. As much of it is what has been characterized as psychological abuse in earlier litigation before this court, and the court is aware of the testimony of Dr. Wilson and the proposed testimony of Dr. Hart and the testimony of Dr. Tyler and the other witnesses who were presented during the first trial on that subject. Overall, the court views that evidence as having little probative value and great potential for prejudice and undue consumption of time. So all those other experts, the experts that talked about abuse and applied it to the brothers' lives and how that abuse affected them and all that, it can't come in. He thinks that it is a waste of time and there's little value to be had from it. Or he just doesn't want the jury to hear about all of the horrific things that Jose and Kitty did to the brothers, therefore keeping out bad character evidence about the victims, basically, is what he's doing. Let me summarize some of that here, he says. Reference to the violence between the parents, the so-called dinners, discussions at the dinner table, the description of Eric Menendez being hypervigilant, or the whole family being hypervigilant, of the arrival of Jose Menendez, the so-called frightening rages of Mrs. Menendez, so-called rule that crying is a sign of weakness, the isolation of Eric Menendez, that Mrs. Menendez would drive fast without seatbelts, that Mr. Menendez, Miss Abramson says, could I back you up, Your Honor? Which aspect of the isolation with Eric Menendez when he was being abused or not allowing him to have friends? Friends, says the court. Okay, thank you. The court says Mr. Menendez's statement of need for high tolerance of pain, as far as that is concerned, that has no relevance to the testimony of Eric Menendez as to the sexual abuse. That's a separate issue. I don't see how they can be related. There is no relevance to that. Swimming, there was no relevance to that. Miss Abramson says, "Could I ask a question?" "No probative value in that," says the court. "Could I go back for a minute to the rage of the mother?" Is the court also excluding the evidence that corroborates that what Eric Menendez testified occurred in the week preceding August 20th, so that week leading up to the 20th, that his mother said she hated them and wished they had never been born? Is the court excluding other witnesses who heard her say the same thing going all the way back to when he was 6? The court says, "If you have a witness who will say that, I'll permit that as corroboration, that that is something that she said when they were children, that there was some circumstantial evidence that perhaps she said that at that age as well, and when the incident occurred in 1989. I don't see any relevance that Mrs. Menendez displayed affection at age 2 towards Eric Menendez, and something occurred which changes between 4 and 6.5. Abramson says, "There, I think, Your Honor, was the way Mr. Menendez was cross-examined about no attachment to his mother and having a superficial attachment, and also the cues of purposely withholding information of his mother's loving treatment of him when there wasn't any. And we were also precluded from trying to introduce evidence of her unloving treatment towards him with any specificity. I think the jury is being given the impression by the cross examination of our client that he's lying. His mother was a saint, and he's lying to make her look cruel when she's actually sweet." The court says, "I don't see that. I think you've had very strong descriptive testimony by Dr. Wilson that the people say they're not challenging as to her character, and I don't see that that is probative on the issue that you're addressing here." Ms. Abramson says, "I think that's one other issue, Your Honor, that I'd ask the court to keep in mind. Beyond whether they, quote, challenge, I don't quite understand how challenge is supposed to play itself out. Let's assume it means for the moment they don't cross-examine Dr. Wilson in such a way to raise issues of the reliability. Does that also mean that Dr. Dietz is not going to come in here and say, so these parents were just spiffy, okay? Or the mother getting angry doesn't matter? Because challenge is not just through cross, but through what they affirmatively intend to prove." The court says, "I'd have to see what his offer is. I can't anticipate that. At this point, I don't even know if he's going to testify." Miss Abramson says, "I think it would be safe to bet that he would, Your Honor." The court says, "Well, I have to wait on that one. I can't make a decision on what he will or won't say and base my rulings on the admissibility of evidence here on what he might not say. It's too speculative. The uncontrolled irritability of Eric Menendez being slapped by Jose Menendez, that relates to an area of testimony that would be admissible, and that has to do with acts of violence or aggression specifically directed towards Eric Menendez. Similarly to the testimony offered by Lyle Menendez of hitting, beatings, and things of that nature, which I would find to be relevant and probative and substantially outweighs its potential for prejudice." My dog is making a ton of noise with his bone. Okay, he's better now. I don't know if you guys can hear that, but he was like sliding his bone around and being really loud. I don't see any relevance in the testimony from 1975 through 77 that Mrs. Menendez was taking prescription drugs or appeared to be spaced out. The reference by Mrs. Menendez to the defendant, Eric Menendez, the description of him as stupid, something of that nature, if the defense wishes to bring that out, that has been testified to by the defendant. And although it is an area of psychological abuse, my concern is that it's going to bring out the so-called rages. Is that part of the same offer, or was that separate? Ms. Abramson says, "There's two separate areas, but basically with respect to it's separate than rages. Let me just put it that way. My recollection of how this witness recalls it is it's separate from the rages. I may not bring that out with this witness, Your Honor. I may choose to change and put it on with the next witness because She saw a longer pattern of behavior, and she saw it in the specific context of physical violence by Mrs. Menendez when trying to tutor Eric Menendez. So I may just hold that for the next witness. The court says, all right. As far as showers together, that has some relevance to the issue of sexual molestation, and I'll permit that. I'm surprised. I think I've covered those things from memory. Miss Abramson says, Judge, there's only one other thing about the rages. And again, it doesn't have to be this witness, but I think perhaps the next witness can describe it in a way that makes it more obvious that there was a threat of physical violence in these rages. The court says, okay, let's deal with that in the context of another witness then. Miss Abramson says, all right. The court says, if you want to bring it out, because I said I'm reviewing this material in light of not just the witness, but other witnesses who you intend to call or propose to call in your offer, who would be describing not so much just events, but circumstances and situations, and would best be described as character evidence, which would be cumulative if offered by more than one on the same general subject. Miss Abramson says, we're trying to show, Your Honor, I think the way we understand it, it's not to show character, but to show relationship and causes for fear relationships. And let me just ask the court. The court did not, there are two areas that I'm very concerned about with respect to Mr. Andersen. The dramatic change he saw in Eric Menendez's behavior from a year before the molestation began to the year after. The court says, that's fine, you can bring that out. Thank you. The court says, since it relates to the issue of sexual molestation. She says, right. And the other thing I'm asking the court is, given the additional detail, to reconsider allowing us to go into the bike incident with Mr. Andersen. He's the only witness now who would testify to that. The court says, I'll let you present his testimony outside the presence of the jury on that subject. I would like to start with his testimony. Do we have the jury here? The bailiff says they're next door. The court says, as soon as they're here, we will start. Ms. Abramson says, okay. The court says, how long will it take them to get here? About 5 minutes, says the bailiff. The court says, if you want to put him on now for that testimony, we can do that while we're waiting for the jury to come out. So is he here? Ms. Abramson says, oh, yes, he's been waiting outside. He may not have realized he was going to be on the stand yet, Judge. Is he outside? The court says, okay, Mr. Andersen, if you would step forward, please. Brian A. Andersen Jr. was called as a witness to the defense. My dog is squeaking his bone, and I'm trying to talk over him. I don't know if you can hear it. Now it stops. Okay. Nope, he's not done. Brian Andersen Jr. was called as a witness by the defense, was sworn in by the clerk, and all that stuff. The court says, okay, Mr. Andersen, we're going to take some brief testimony from you without the jury here on specific instance or incident. So Ms. Abramson says, can I lead for the foundation, Your Honor? He says, yes. So going on to direct examination, no jury with Brian Andersen Jr. Ms. Abramson says, in 1977, during the summer, did you live with the Menendez family, Jose and Mary Louise, and their two sons, Eric and Lyle? Yes. Was that when they were living initially that summer in a house in Muncie, New York? Yes. And at the end of that summer, did you help the family move to a house in the Princeton Junction area of New Jersey? Yes. And was it your understanding that at that time that Eric Menendez was 6 years old, going on 7? My dog is destroying my pillow. Hold on 1 second. Sorry. Okay. At the end of the summer, did you help the family move to a house in the Princeton Junction area of New Jersey? Yes. And was it your understanding that at that time, okay, now he's eating my feet. This dog. About to give him a timeout. Okay, sorry about that. Here, I have a toy for you. Eat that, not my feet. He says yes, he was helping the family. Was it your understanding that at that time Eric Menendez was 6 years old, going on 7? Yes. Did you observe, or on more than one occasion, Eric Menendez being dealt with, if you will, on a bicycle with his father? Mr. Khan says, I will object at this point as leading. The court says, well, she wanted to get to the issue here. He had no way of knowing what it would be asked, or what it would be until he was asked. So overruled. Ms. Abramson says, right. The witness says, yes. Ms. Abramson says, did you see what we've called the bicycle riding incident? Yes. The Monsey house, the street that ran in front of the house, did it end in a cul-de-sac at each corner? Yes. Was one of the cul-de-sacs downhill from the house and the other one uphill? Yes. Did the bike ride incident take place in the direction of the cul-de-sac that was downhill? Yes. Would you tell the court, as best you can, Eric, describe what, first of all, were you outside watching? Yes. Was anyone else outside watching with you? Yes. Who else? Kitty and Lyle. And would you describe what you saw Jose Menendez do with respect to Eric Menendez and the bike riding? All right. So Kitty, Lyle, and myself were on the front lawn of the house. Jose and Eric were in the street, put Eric on the bike, ran him in the, as you're looking out the house, it would be off the right, going down the hill. Pushed Eric, there's no training wheels on the bike at this time, pushed Eric, I'd say about 20 feet, let him go. The boy went down the hill, fell. Jose ran down and picked him up. The boy had pants and his pants were ripped and the leg was bleeding. Put him on the bike. I don't know what the hell he's barking at now. Hold on. Sorry. So put him on the bike and continued. So his pants were ripped and the leg was bleeding. He put him on the bike and continued to further him down the rest to where the cul-de-sac ended. Couldn't turn around. He slowed down enough to where he fell down, walked the bike back up on top of the hill and put back on the bike. So he was put back on the bike after he fell again. And then again went down, and this happened back and forth numerous times. Towards the end of the session of the bike training, he fell and his elbow was noticeably swollen. And in his arm area, it was cut. Myself, stood up to help because Jose went down and picked up Lyle. Eric and picked up Eric and put him back on the bike. Kitty told me not to do that because Jose was taking care of the situation. Well, before you get there, first of all, did you see bike training on more than one day like that? Yes. And on each day, how many days do you think you saw this? 3, that I could remember. And on each of these days, did Eric repeatedly fall? Yes. And on each of these days, did Jose put him back on the bike and push him again? Yes. On the day that you're talking about, was that the only time that you saw Eric actually cut and hurt and put back on the bike? Was the first day. This was the first day? The first day, says the witness. Now, did you, after Eric Menendez had the swollen and the bleeding elbow, was he put back on the bike? Yes. Was he pushed again? Yes. What was Eric Menendez's demeanor each time that he was put back on the bike and pushed? He was frightened. He didn't want any part of it. Well, don't describe it in a conclusion. Describe what you saw. He was frightened. Was he crying? Yes. Did you hear him say anything to Jose Menendez before he was put back on the bike after he was injured? Daddy, I don't want to do this anymore. And when he said that, what was his demeanor? Who, Jose or Eric? Eric. He was frightened. He just had this look on his face. Was he crying? Yes. And after he received the injury to the elbow, when he was pushed down the hill again, did he fall again? Yes. Did anyone go to assist him? Jose did. Did you try to go assist him? Yes. And what happened when you tried? Kitty stopped me abruptly. And she said, "Don't do that. Jose is dealing with it." Correct. Did Jose, when he went to Eric, comfort him? What did he do when he went to him? He grabbed him by the opposite arm and walked back up with him, and the other arm dragging the bicycle. At the point of reaching the property line, Eric ran to his mother. Jose proceeded to go to the garage and physically just throw the bike into the garage, did not place it in the garage. When Eric ran to his mother, what was his demeanor? Scared. He was hurt. He was just crying. He was hurt, holding his arm. What was Jose Menendez's demeanor towards Eric Menendez after he got him that last time and brought him back? He was upset with Eric because he could not grab hold of the concept of riding a bike. He was angry. Yes. When Eric Menendez was placed back on the bicycle after he injured his elbow, was he able to use that arm to steer with? No. So at that point, when he was pushed again by Jose Menendez, the court says, "Hold on, let's stop here. The jury is coming in, so we're going to stop and let the jury get in the jury room." The court says, "Okay, the jury is here, so rather than continuing this examination," Ms. Amerson says, "I have just one more question." The court says, "At this point, we'll do it after we have other testimony in front of the jury." She says, "I only had one other question." Says, "Just this last question?" "Thank you." Did you observe that when Eric Menendez was put back on the bike after injuring the elbow, he did not hold the handlebar with that arm? He favored the arm. So he didn't try to steer with it? No. That's all I had, Your Honor. The court says if there's cross-examination, that will be done later. Would there be? Mr. Khan says yes. The court says, "Okay, let's get the jury out then." Ms. Abramson says, "I assume I can do the ordinary, simple, foundational things." The court says, "Of course." The jury enters the courtroom and the following proceedings were held. The court says, "The jury is in the jury box. Good morning, almost good afternoon. I'm sorry for the delay, but as I said, we were in session last week. There are some occasions when we'll have hearings and discussions with the lawyers, and sometimes it takes a little longer than anticipated. We try to keep it to a minimum, but they crop up now and then, and I apologize for that. We're now going to resume with the trial and another witness than the one who was on the stand when we recessed last Friday. That witness, Dr. Wilson, has some scheduling problems and won't be available until later this week. So we'll pick up with him when he comes back. But at this point, we'll keep going with the trial. We'll have other witnesses who will testify at this point. We have a witness who's here now just for convenience. He's already on the witness stand. We'll ask that you state your name for the record, sir. He says, "Brian A. Andersen, Jr." The court says, "Okay, you have been sworn in and you're under oath. You may examine the witness." So direct examination begins. Ms. Abramson says, "Mr. Andersen, do people ordinarily refer to you as Alan Andersen rather than Brian Andersen?" "Yes, Alan." "Is Brian Andersen Sr. your father?" "Yes." "Was Brian Andersen Sr. the brother of Mary Louise Menendez?" "Yes." "Therefore, are you the nephew of Mary Louise Menendez?" "Yes." "What is your relationship, therefore, to Eric Menendez and Lyle Menendez?" "First cousins." "Where did you grow up, Mr. Andersen?" "Oak Lawn, Illinois." And hold on. Okay. I was just getting a bunch of notifications for something. Distracted me. First cousins, he says. "And where did you grow up, Mr. Andersen?" "Oak Lawn, Illinois." And do you recall strike that, if you take a look at what we've called the family tree, of course, it isn't at all like a tree, but this exhibit is in the trial 106. Does your name appear there under the name of your parents, Brian and Pat? Yes. And you are, therefore, an Anderson relation, and you are the child of the third child of Charles and May Anderson? Yes. And your Aunt Mary Louise, or Kitty Menendez, was the fourth child of this marriage, correct? Yes. Did you visit the family when they were living in a variety of homes? Yes. And do you recall where the family was living when you first laid eyes on either Joseph Lyle Menendez or Eric Menendez? Yes, it was in Hinsdale. Well, let me call your attention to what's called the Menendez family houses. This chart that contains a series of individual exhibits and ask you, first of all, calling your attention to what's called Cedar Grove, New Jersey. In that, is that house familiar to you? Yes, it is. Did you ever visit the Menendez family at that house? Yes, I did. When the family was living at that house, were both of the Menendez sons born or only one? Only Lyle was born. And is it your understanding that Lyle was born in 1968? Correct. And that Eric was born in November of 1970? Correct. Now you mentioned the Hinsdale house. On this board. There's an exhibit numbered 349C. This whole chart is 349. Do you recognize that house? Yes, I do. And what is the relationship geographically of Hinsdale, Illinois with Oak Lawn, Illinois? Besides the fact they're both in the same state, they're about 30 minutes apart. They're in the same part of the state as well? Correct. Are both of these areas, Hinsdale and Oak Lawn, in the greater suburbs of Chicago? Yes. And when you visited the family at the Hinsdale home, what were the occasions that brought you there? Just the families coming together. Well, did you visit at the Hinsdale home with your parents, Brian and Pat Andersen? Yes. Now, did you ever visit the Menendez family when they lived in New York? Yes. Was that the same kind of visits where your parents and you would go to their family, or was it different? It was different. What was the nature of your visit when the family lived in Muncie, New York? Summer vacation, to spend time with my cousins. Did you spend your whole summer vacation with the Menendez family in Muncie, New York? Yes. Did you do that once or twice? Twice. Does this photograph 349D accurately depict what the Muncie house looked like at the time that you were staying with the Menendez family? To the best of my knowledge, yes. Did you also spend any time with the Menendez family when they lived in Princeton Junction, New Jersey, in a rented house on Mill Road? Very briefly, yes. Was that 1977? Yes. Did the Menendez family, move from Muncie to Princeton Junction at the end of the summer of 77? Yes. And did you assist them in that move? Yes. Were you a guest at their house that entire summer? Yes. And did you remain with them for some period of time after the move to New Jersey? Yes. What is your year of birth, Mr. Anderson? 1961. So you were a good deal older than your cousins Eric and Lyle Menendez when you stayed with them those summers, correct? Yes. Do you recall how old you were for the summer of 75, sorry, 1975, when the family lived in Muncie? That would put me at 12, 12, I believe. And the last summer that you were there, you said you were born in 61, no, November 11/10/61. That would put you at 14? 14. And the last summer you were there was 77, correct? And he says correct. And you would have been 16? Correct. When you stayed with family, the Menendez family, when they lived in Muncie and then Princeton Junction, did you have the opportunity to spend time alone with Lyle Menendez and Eric Menendez? Yes. Did you do babysitting with them during those summers? On occasions, yes. Did you notice any difference in Eric Menendez? Any change in him between, well, strike that. Did you notice a change in him from the 75 visit from the 77 visit? Yes. And could you describe, first of all, the degree of this change, and then what was it that you saw? In 1975, he was a very up child, very enthusiastic, very open. In 77, it was a complete 180. He was very introverted, withdrew from myself, was so quiet, it was almost impossible to get him to talk for me for any reason. And he played by himself a lot, would not like any interference from his brother or myself to even be with him, which I found very unusual. Now, with respect to 1975, you said he was outgoing. Did he appear to be at that time? Could you describe what his general mood was or attitude was? Was he a happy child, a sad child? What? He was a happy child. Was he friendly in 75? Oh, yes. And did he come to you? Oh, yes. Was there ever any behavior between yourself and him that could have caused his acting differently towards you 2 years later? That I know of? No. What you saw him, when you saw him 2 years later in 77, would you describe him as happy then? No. How would you describe him? Objection, calls for speculation, overruled. He says, extremely sad, like I said, introverted, withdrawn. When approached with a question, would hesitantly answer it or not answer at all. And also he would walk away from me and I wouldn't pursue him. I would just leave it alone. Did you detect any emotion when you would try to talk to him on his part? His eyes would not be smiling. He would not have the happy eyes. His eyes would look more plain and dazed to where he was almost like confused, it seemed. Did he appear to be afraid of you or afraid to talk to you? Afraid to talk to me, nervous. Now, at this time, Mr. Anderson, in the summer of 1977, did you understand that Eric Menendez was 6 3/4 going on 7? Yes. And you understood that the preceding visit, 2 years before, he was 4 3/4 going on 5? Correct. Did anyone in the family explain to you what had happened to Eric Menendez between 4 3/4 and 6 3/4? No explanation was offered, nor did I ask any adult. When you were living in the Menendez home over the course of 2 summers, was it apparent how the family was run and managed? Yes. And who was mainly in charge of the family? Jose. Did his expert did he exert his position through, well, can you describe what his style of being in charge of the family was, very briefly? Objection irrelevant, sustained. Ms. Abramson says, did you see, based on your observations of watching Eric Menendez around his father, whether or not Eric Menendez displayed any fear of his father? Objection calls for speculation and irrelevant. Overruled. Yes, says the witness. How would you describe the degree of that type or the type of that fear? Extreme at points. Shall I go on? As best you can describe it. We are talking 1977, correct? Well, either one. Well, did it change? Did the father change the way that he ran the Did the father that was the dog. Did the father change the way that he ran the family between 75 and 77? As far as he became meaner, I saw him being meaner in 77, more objection, non-responsive. Motion to strike, says Mr. Khan. Sustained. The answer stricken. Why can't he say he was meaner? Did you see Mr. Menendez being meaner to Eric Menendez in 77? Objection, irrelevant, evidence code section 352. The court says calls for a conclusion on the part of the witness. Sustained. The question has to do with Miss Abramson says, fear. I'll turn it around. Thank you. Did you see Eric Menendez displaying obvious more fear of his father in 77 than in 75? Yes. And if you can tell us, how was that fear demonstrated? How did Eric look, or what did Eric do? If Jose would raise his voice and or Jose had a tendency of taking his belt off and leaving it on the coffee table, as soon as that happened, he would leave the room, go in his room, or he would become so quiet he would not even know I would not even know he was there. When you say he, who are you talking about? Says the court. The witness says, I'm sorry, Eric. He would become so quiet you wouldn't even know he was there, or he would go and sit by his brother or myself. Ms. Abramson says, you would note a change in his behavior yourself based on Mr. Menendez raising his voice? Yes. Let's talk about the belt. Did Mr. Menendez have a way of behaving with respect to his belt? Yes. Was it your observation, having lived there, that the belt was used to discipline? Yes. Was the belt used to discipline in two different ways? Yes. Okay, would you describe first, was there a way in which the belt was used short of actually striking the child with it? The belt, once laying on the coffee table, would be taken and folded and then would be snapped to create the attention of all of us to look at him. And at this point, to look at whom? Mr. Anderson? To look at Jose. For Eric, Lyle, and myself. Even Kitty would look at Jose. And at that point, he would then go into what happened within the day that made him upset, per Kitty's conversations with him, and would ask, is this true? And in 19, Mr. Khan says, I would object as non responsive, motion to strike. Court says the answer will stand, but let's go on to the balance of the question. Ms. Abramson says, let's do some background. Mr. Menendez worked during these summers that you stayed with the family? Yes. Let's focus on 1977 for the moment. When he would get home, was there a usual order to which he would interact with members of the family? Objection, irrelevant, sustained. Did you observe Mrs. Menendez talking to Mr. Menendez after he returned home and informing him of behaviors of the children during the course of the day? Mr. Khan says objection, irrelevant. The court says overruled. I'll permit the question. The witness says yes. Ms. Abramson says, and would it be after these conversations with Mrs. Menendez that Mr. Menendez would then take the belt off? Was this a belt he was wearing? Yes, it was a belt that he wore to work. Yes. And so he would take off the belt? Uh-huh. And then he did something with it? Yes. What did he do? He would sit it down first, and then it would be laying on the coffee table, and then he would just pick it up because we'd be watching TV usually 99% of the time, and he would just snap it. And we looked and tried to remember back in the day what happened, and then he would state, Kitty told me this is what happened today. And he would ask, is this true? And we would answer truthful. Yes, it happened. The court says, okay, you've answered the question. Next question, please. Miss Abramson says, following that, well, strike that. Did you observe Eric Menendez's behavior and demeanor during these times with his father when his father is snapping the belt and then talking about what happened during the day? Yes, yes, I did. How would you describe how Eric appeared? Flat out coward, just would sit there and sometimes he would shake. Did it appear he was shaking from the cold or something else? Objection calls for speculation. Overruled. From the fear of his father's voice. Ms. Abramson says, and were there times when either after one of these discussions by Mr. Menendez or even in the absence of one, when you heard the belt actually being used? Yes. And how did what was the routine for when the belt was actually used? Well, the boys were either one-on-one with Jose or as a pair would go into their bedroom, which was next to mine. Would they go in there by themselves or would someone be in there with the bedroom with them? No, Jose would either take one of the boys or both of the boys into the room and shut the door. Could you then hear certain sounds coming from that door? Yes. What did you hear? First, yelling, and then the slaps of the belt. And the witness, claps his hands together to mimic the sound. He says, hitting. So who was doing the yelling? Based on the tones of the voices, I could tell it was either one of the boys, Lyle or Eric. When you say yelling, what do you mean? Jose yelling at the boys for disciplinary, what I believed, and following thereafter would be the striking of the belt. Did you hear any sound in addition to the striking of the belt? The boys pleading for their father to not hit them. Did you hear any other sounds from what you believed were Eric and Lyle Menendez? Well, in my room, did you hear them trying or crying out or anything like that? Yes. Which one? Was it one that you would hear crying after the hitting or during the hitting? During the hitting, it would be one, yes. Did you hear that from both Eric and Lyle? I did hear two different tones, yes. My question is, were there times when Mr. Menendez would be in there just with Lyle? As a one-on-one type thing? Yes. Yes, the boys, yes. And were there occasions when you heard the sounds of the belt striking when it was just Mr. Menendez and Lyle? Yes. Did you ever hear Lyle cry out? Yes. Did you ever hear him cry out as if in pain? Yes. Is the same true with respect to Eric Menendez? Yes. And were there times when they would both be in there and you would hear the belt hitting? Yes. And you would hear each of the Menendez boys cry out? Yes. And following any of these sessions in the room, first of all, how many blows with the belt would you usually hear? That I remember, I heard instances, the reason how I feel I know both boys got strapped. Mr. Khan says, I would object, non-responsive. Sustain the answer stricken. Miss Abramson says, let's say it's an occasion where just Eric Menendez alone is being strapped by his father. Okay. Okay. What typically was the number of blows that would be struck? 3, 5? And was this discipline being struck with the belt? Did this occur when Eric Menendez was 4 3/4 in the summer of 75? No, 77. So this was something that was happening after he was 6? Yes. And did you ever observe any kind of marks on him following any of these strappings? Oh, yes. What did you see? Bruises upon his buttocks, upper thigh, lower back buttocks area where they meet. Did you ever observe Eric Menendez to have any difficulty ambulating or walking or moving about after any of these strapping sessions? Usually, after every one, yes, very stiff. Did you make any observations of any marks on Lyle Menendez after any of the strapping sessions that he was involved in? Same. Also bruises? Yes. Same area, high up on the back of the leg? High up on the back of the leg, the middle of the upper buttocks area, and also with Lyle, there would be hand marks where Jose would have held him. He had very strong hands. Who did? Jose. This would be on Lyle. Did you ever see Jose Menendez actually? You had gestured there with your upper left arm? Oh, yes, that is something. Yes. I'm only trying to make a record. Okay. So you were gesturing to the area from your left elbow up to your left shoulder. Correct. In the bicep area, indicating that that was the place where Jose Menendez had grabbed Lyle Menendez's arm? Yes. Did you see that happen more than once? Oh, yes. Did you see bruises on Lyle? On his arm in the area more than once? Yes. Were you ever grabbed by Mr. Andersen in that part of your body? Yes. Is that what is that what you base your statement on, that he was very, very strong? Oh, yes, yes. Did he bruise you? Yes. And you were 14? Yes. Did he bruise you when you were 16? Yes. Now, can you tell me, first of all, over the course of the summer of 77, on approximately how many occasions do you believe you observed Eric Menendez being observed through hearing and through what preceded it, Eric Menendez being hit with a belt by by his father. It was an often occurrence, and it's hard to put a number on that. It was often. It's hard to put a justifiable number on this. I could say 20, I could say 30. I mean, well, let's try for the low end. Did it happen every week? Yes. Did it happen more than once every week? Yes. Now, can you remember, Mr. Anderson, what it was that Eric Menendez did that resulted in him being strapped with a belt on his skin by his father? Two instances that stand out in my mind are one, leaving the property line, and also climbing the fence in the backyard. Let me stop you there for a minute. When you say leaving the property line, the photograph that's been marked 349, that shows the front of the house, the Monty house, correct? Yes. The front of the Monty house had the lawn in front of it, correct. But no fence. No. And there was a street in front of that? Uh-huh. No sidewalk? No. And were there houses across the street? Yes. And when you say you remember an incident where Eric Menendez left the property, where did he go? To follow me. Where were you going? To a neighbor boy's house, kitty corner from their house across the street. Kitty corner? Yes. So the camera, in looking at this photograph, the camera is on this side of the street that you were crossing over to? Correct. They lived in the intersection right there. They lived on the corner. So the street, went like he's gesture somehow. It was a big area. So the Menendez house was a corner house? Correct. Was the house that you were going to, if we're looking at this photograph now, was the house that you were crossing the street to the left of the photograph? Coming out of the house, you had to go, yes, to the left. You had to leave the house to the left. So coming out of the house, you went that way? Yes. So it would be to the right of this photograph. Correct. Was there someone that lived there that you played with? Yes. A young man, a kid like yourself? Yes. So was this daytime or nighttime? Daytime. And you had left the home and crossed the street? Yes. And did you then see Eric Menendez? Yes. And he would be screaming my name for me to wait. Then what happened? I would turn around and tell him that his mother didn't give me permission to watch him at that time. It was Lyle that was with me, and he was following Lyle Menendez and myself. And I told him to turn around and go back. He wanted to be with us at that point, and at this point, Kitty came running out of the garage and just grabbed him and pulled him up and took him back in the house crying. How far away from his property had he gotten before she did that? Just across the street. Was he strapped with a belt by his father for doing that? That night, yes. Objection calls for speculation as to the reason why he was struck. Overruled. Abramson says, and did Mr. Menendez explain, did he come home and do the strap thing with the belt and talk about this matter? No, he did not. Well, how do you know that's why Eric Menendez was strapped? He was taken in the bedroom one-on-one. And that was the only thing that had happened that day? Objection calls for speculation, no foundation. Sustained. Ms. Abramson says, let me ask you something. On those occasions when you heard the belt hitting and you heard the sound of voices and crying from the Menendez brothers' room, where were you so that you could hear this? Either I was in the front room or my bedroom. Were there occasions when Mr. Menendez would take one or both of his sons back to their room? Yes. Were there times when he did that when he had the belt in his hand? No. Were there times when he did that you believe they were to get belted, strapped? Maybe I'm confusing you. You are. So, were there times when one or the other of the Menendez brothers was in their bedroom and their father was disciplining them with the belt? Uh huh. And you were in the front room with Mrs. Menendez? Correct. Was there something that Mrs. Menendez would typically do when you and she were in the front room and Mr. Menendez had taken one of the brothers to be disciplined? Objection, irrelevant, overruled. The witness says, yes, there would be. Ms. Abramson says, what did she do? In 75, I was told that when, not what you were told, says the court. Ms. Abramson says, we'll get to what you were told. Did she do anything with respect to the television, for example? Turn it up. Turn up what? The TV. The sound? The sound, yes. And would she turn up the sound as soon as Mr. Menendez had gone into either of the brothers' rooms? As soon as the door closed. In the Monty house, did Eric and Lyle Menendez share a bedroom? Yes, they did. So he would go in the same room with whichever brother he was with. Correct. Were you given instructions by Mrs. Menendez concerning what you were or were not to do with Jose Menendez when he went in his son's bedrooms with either of them? Yes, I was. What were the instructions that you were given? I was not to eavesdrop outside the door, to leave my position in the front room. I was to stay in the front room and not even make advances towards that door. You were told to stay away when he was alone in the bedroom with his sons? Correct. Did you ever see Mrs. Menendez approach the bedroom when Mr. Menendez was in there disciplining either of his sons? No. Were there occasions, Mr. Anderson, when Jose Menendez would take Eric Menendez into Eric Menendez's bedroom for non-discipline purposes? Objection. Calls for speculation. Sustained. Did you ever hear Mr. Menendez ask Eric to go into his bedroom with Mr. Menendez to play? Yes. And when Mr. Menendez would go into Eric Menendez's bedroom to play, was the door closed? Yes. Was the door locked? He says something unintelligible. The reporter says, wait, wait. The court says, what was your answer? The witness says, unknown. The court says, you did not know one way or another if it was locked? The witness says, no, because I was not allowed. The court says, we're just trying to make out what you said. No or unknown? Ms. Abramson says, it's unknown to you whether he locked the door? No, I did not know. You've anticipated my next question. Did you ever go down to the bedroom when Mr. Menendez was in there playing with Eric? No. Why was it? Or why is that? Because, can I be candid? Certainly. I was told by Kitty that when Jose Menendez was in the room with either one of the boys, or both, you do not approach or go near the door. No matter what the reason? No matter what reason. Now, apart from these two, well, you said you remembered one incident where Eric Menendez, you just described, crossed the street and he got strapped that night? Correct. Was there another incident having to do with him and a fence that resulted in a beating with the belt? Yes. What did he do on that occasion? He being Eric Menendez. He just climbed the fence and Kitty caught him and ran down the deck in the backyard and proceeded to. The fence was tall and she had to jump up and grab him off the very top of the fence. He had climbed up to the top of the fence and this was in the backyard? Correct. And he wasn't allowed to climb on the fence. As far as Kitty was concerned, I guess not. Was she angry with him? Did she yell at him? Yes. Did she say anything about telling his father? Correct. What did she say? Wait until your father gets home. He will know what you did. And when his father got home that night, what happened? Eric would not approach his father. Well, what happened after that? Jose came home, went in the kitchen. We were in the front room. Jose came out of the kitchen, asked Eric, did he climb the fence? Eric would not respond to him, asked him again. Eric then responded in a very, very soft yes. He proceeded then to take Eric into the room. With the belt? There's two scenarios with the belt. There's a belt he wore that he came home and he took off and laid on the table. Then there's a belt he had always hanging in the closet in their bedroom on the coat rack. It was always there. Always a dress belt in the closet on the coat rack. Always. And you saw it there? Oh, yes. And was it your understanding that that belt hanging in the closet was used for strapping the brothers? Objection calls for speculation. Overruled. The witness says, I know for a fact because the belt never left the front room when they went to discipline the boys. The dress belt he wore that day was still in the front room on the table. The belt he wore never left the kitchen table where he used it to threaten them. The actual belt that he used was hanging in their closet. Saberson says, I see. So he would snap the dress belt that he wore and put it on the table. Correct. And this was to indicate that someone was going to be belted. That was, and it indicated, well, to get our attention is basically what I believe that was for. To scare them, to intimidate them, to threaten them. And then when he actually went to belt Eric or Lyle Menendez, he used the one that was in their bedroom? Correct. So the dress belt was like a sign, the belt's coming, or the belt's going to happen. Correct. Even though it wasn't that particular belt. Correct. And this night, the night that Eric climbed the fence, he was strapped with a belt in his bedroom? Yes. Now, would there also, Mrs. Anderson, based on your recollection, Mr. Anderson, what was the worst thing that you can remember Eric Menendez doing that resulted in his getting strapped with the belt? Objection calls for an opinion and speculation and no foundation. Sustained. Something that you observed that you now or that you know resulted in a strapping. What was the most? The court says, I think we've already gone over that. Let's go on to something else. Ms. Abramson says, there's one other. Was there an incident where Eric spilled something accidentally? Objection, irrelevant. Sustained. Ms. Abramson says, was Eric Menendez strapped with a belt for things that happened by accident as well as for things on purpose also? Objection, irrelevant. Evidence Code Section 352. The court says this is the last question on this act. Ms. Abramson says, exactly. Court says overruled. The witness says, I can answer that? Yes, says the court. Yes, there was. Ms. Abramson says, with respect to the way that the family was organized, were both Eric and Lyle Menendez involved to a high degree in sporting activities over the course of both of the summers that you spent with them? Yes. Did you have any real free time by the summer of 77? Mr. Khan says, objection, irrelevant, no foundation, calls for speculation. The court says sustained. Ms. Abramson says, did you get to meet any of their friends? One. Objection, irrelevant, says Mr. Khan. The court says, all right, he's answered the question. The answer will stand. Ms. Abramson says, is it your understanding there was more than one friend, but you only got to meet one, or there was only one? Objection calls for speculation. Sustained. Ms. Abramson says, were Eric or Lyle ever disciplined with the belt for failing to perform properly in sports? Objection calls for speculation, no foundation. Sustained. Abramson says, were sports performances discussed regularly in the household? Objection, irrelevant. Sustained. I just need a moment, Your Honor, to skim over. The court says, sure. At any point, with respect to the incidents where Eric Menendez was strapped with a belt, at any point did you see him rebel against his father in any way? Yes. What would he do? Eric? Yeah, Eric. I'm only talking about Eric now. He would run away. He would fight. And when being dragged to his room, he'd be screaming at him. Trying to resist? Yes. And when he ran away, did he run to his mother? At times, yes, most of the time. Normally, he ran in the dining room and hid under the table. So he would try to hide. Yes. And he would try to resist? Correct. When he ran to his mother, did she protect him? No. What would she say when he ran to his mother to avoid strapping? You must go with your father and take the punishment. So when he was running and hiding or something to resist, did he appear afraid? Yes. Would Mr. Menendez participate with Eric and Lyle Menendez on the weekend in sporting activities? Objection, irrelevant. It's foundational, Your Honor. Overruled. The witness says yes. Following their participation in sports, was there something that Jose Menendez did with his sons? After every sporting event, when we returned to home, the three of them would take a shower together. After every sporting event, the three of them took a shower together. What would be the father? That would be the father and both sons in the master bathroom. The master bath. Now, did you observe times when Mr. Menendez displayed anger towards Eric? Yes. Would you characterize the level of that anger? Objection calls for speculation. Also, conclusion on the part of the witness. Sustained, says the court. Ms. Abramson says, did she get upset? Yes. How upset? Objection calls for speculation. Sustained, says the court. Ms. Abramson says, did she assume a particular physical posture when she was expressing anger towards Eric Menendez? Objection, irrelevant. All right, let's take our break, and we'll resume at 1:30, and we'll talk to the lawyers about this objection. Don't discuss the matter with anyone. Don't form any final opinions about it, and we'll resume at 1:30. The witness says, I could leave. The court says, wait until the jury gets out. The jury exits. The court says, okay, the jury has left. If this is an effort to obtain a description of characteristic of Mrs. Menendez as to how she displayed herself in a certain way towards the defendant, Ms. Abramson says yes. If it is, then you can pick a witness, but I don't want it to be repeated over and over with other witnesses. Ms. Abramson says, well, I think, Your Honor, it's a matter of one question per witness, frankly, just to show it didn't stop and how young it was when it started. I'm most interested, not so much in how she looked, but how he looked when she was doing this. I'm trying to elicit evidence that her rages, as they were, frightened him because I think fear is the crucial component. He's reacting to what she's doing. So that's what that's where I'm trying to go. Perhaps after lunch, I'll try to make it simpler with the witness so he will know where we're going. The court says, okay. Ms. Abramson says he was not privy to our discussion or the court's ruling. The court says, okay, we'll be resuming at 1:30. That's it, says the witness. The court says yes. So they go to lunch. And that is where we are going to end for today. We will continue with Brian Andersen Jr.'s testimony in part 72. So thank you guys so much for watching, and I will see you in the next one. Take care. That's the end of this Trial Transcripts Exposed. Thanks for following along with me. Like if you want more, subscribe, and let me know what you think in the comments below. See you next time.